All right, so our last substantive video of the semester is about the discussion section and application in particular. Remember that the keys to application are as follows. 1, your application refers to the rules and to the explanation. 2, you make specific comparisons for the reader, not general, but specific. You do the work for the reader, that you don't waffle. And again, remember your application should be both explicit and specific. So to write an application, you need to start each concept with a conclusion or a point of analysis. That point of analysis should relate to the hook from the explanation section. You need to remind the reader of the rule for the concept. You need to remind the reader of the explanation cases and how they dealt with the concept. Then you need to apply the rule to your case by analogizing or distinguishing the cases from your explanation section. Before you get to this, though, you need a transition. If you remember from the rubric, if you see a big X in application, it's probably for this. First paragraph begins with a sentence that signals a transition to application and summarizes the result when applying the law to the facts of the case. That means that you are applying the conclusion of the subsection based on your rule and your explanation. And it should be the same conclusion that you had in both the opening C of CREAC and the closing C of CREAC. So, for example, in this case, a court would likely find that Officer Muntz had reasonable suspicion for the investigatory stop because Detective Nadori corroborated the anonymous tip and Ms. Packer remained nervous and fidgety throughout the consensual encounter. That transition sentence should be supported by law. And as is new for you this memo, but as is needed, you also need a cite to the facts that support, a cite to support the facts that you are relying. Once you get past the transition sentence, then you start with your point of analysis. Again, on the rubric, each paragraph begins with the point of analysis that accurately represents the subject of the paragraph and demonstrates the relevance of the subject to the main issue or sub-issue being discussed. So if we go back to hooks and points of analysis, if the hook in your explanation section was an officer's display of authority, such as issuing a direct order, using emergency lights, and or threatening behavior can amount to an investigatory stop, which of course the hook would also have a citation after it, your point of analysis would be something comparable to this. The court would likely find that the consensual encounter matured into an investigatory stop when Detective Nadori joined Officer Muntz in Ms. Packer's questioning. The police vehicle's emergency lights were on, and Officer Muntz ordered Ms. Packer to remove her hands from her pocket. Noting that in the hook, you talked about a display of authority, emergency lights, and behavior. Here you have Officer Nadori joining Officer Muntz, which could be threatening. The police vehicle's emergency lights were on, and Officer Muntz ordered Ms. Packer to remove her hands from her pocket. Again, the point of analysis should be supported with a citation to authority and also a citation to the facts that you are relying on in that point of analysis. When you get to the analogic reasoning in your rubric, one says includes non-conclusory, objective, and thorough explanations of the way that the rule applies to the client's facts. The other says displays consistency with and reference to as appropriate rule explanation section, analogizes, distinguishes, and reconciles as applicable the cases discussed in the rule explanation. So what does that look like? Well, it could look like this. In Gibson, the court determined that the presence of positioning of two officers with one officer standing in front and another closely behind, combined with the officer's request that the defendant remove his hands from his pockets, created a show of authority which a reasonable person would feel compelled to comply with. Note the cite to Gibson. Similarly here, the presence of both officers, coupled with Officer Muntz's request that Ms. Packer remove her hands from her pockets, created a show of authority where a reasonable person would feel compelled to comply. So remember, you're going to try to mirror the language so that the reader automatically sees the comparison. So here you had in Gibson created a show of authority. In your case, you have created a show of authority. In Gibson, you said a reasonable person would feel compelled to comply with. Here you say where a reasonable person would feel compelled to comply. But it doesn't end there. You then need to follow with specific and explicit facts from your case to explain what happened. And if anything is different from Gibson, you would explain that you have differences and why they do or they don't matter. Let's show how to analogize one more time. As in McKell, where the court held that a sufficiently corroborated tip from an anonymous tipster, along with additional circumstances, was enough to establish reasonable suspicion, that's reminding the reader of the rule. The court in Ms. Packer's case will likely find that the corroborated tip, coupled with the officer's observations, created reasonable suspicion for the stop. So we reminded them of the rule from the explanation. Now we get into details. In this case, the anonymous tipster reported seeing a dark-haired woman wearing a crop top and torn jeans breaking into cars. Cite to your record. The tipster stated that he saw a woman in the front seat of a black Lexus or Honda and that she moved onto a dark blue car and was rummaging through that car's glove compartment. Cite to your record. Detectives Nadori's investigation found a black Honda with the window pried open and several items from the glove compartment on the passenger seat, and a blue car with the driver's door unlocked and the glove compartment opened. Cite to your record. Here, Detective Nadori's corroboration of the reported crimes, coupled with Miss Packer's matching the description of the woman described in the anonymous tip, and Miss Packer's attempt to leave the area, collectively support a finding of reasonable suspicion. Cite to McKell and cite to your record for those facts. You see how specific that was? That wasn't a gloss over. That was specific. Moreover, in Hudson, the court found that an officer had reasonable suspicion when he received an anonymous tip about burglaries in the area, observed a man who roughly matched the suspect's description walking away from the reported crime, and without corroborating the tip, stopped the individual. Citation to Hudson. Here, when the officers arrived on the scene, they found a woman with long brown hair wearing a dark crop top and jeans, walking quickly out of the parking lot. Cite to your record. Based on the court's holding in Hudson, because Ms. Packer roughly matched the description provided in the anonymous tip, and because the officers saw Ms. Packer attempt to quickly walk away from the parking lot, there was reasonable suspicion for the stop. Since Hudson is named in that last sentence, the cite can be just to the reporter that there was. Hope that helps how you should analogize. There should be a citation to Ms. Packer roughly matching the description. So when you are comparing things for analogies, make sure that you are comparing a thing to a thing, like the anonymous tip in Campuzano, which the court found. Here, the anonymous tip. Or comparing a party to a party, like in JL, where the suspect. Here, Ms. Packer. If you are looking for terms of comparison and you are running out, go to your textbook on page 297. There is a chart that has terms of comparison, terms of contrast, etc. But you don't stop there. You're also going to have to distinguish, especially if you're raising counter-analysis. So let's talk about how to distinguish. In Johnson, the court found reasonable suspicion for an investigatory stop because the defendant was located near a hospital, shaking violently and reaching for a bulge in his pocket. Cite to Johnson. In contrast here, Ms. Packer was in a parking lot, fidgeting and taking her hands in and out of her pocket. Cite to your record. Furthermore, the defendant in Johnson was alone in a suspicious area in the early morning with no reason for being there. Unlike here, where Ms. Packer was in the college town parking lot outside of a college bar with other bar goers and told the officer that she was in the lot to retrieve her apartment keys from a friend's car. Cite to both Johnson and to your record. Because she was in a place where other college students were congregating, her nervous demeanor was not sufficient to create reasonable suspicion. Cite to Johnson. Moreover, unlike Cruz, where the court found that based on a totality of the circumstances, the officer had reasonable suspicion to justify approaching the defendant, here, Officer Muntz did not have reasonable suspicion to justify an investigatory stop. Cite Cruz. In Cruz, the defendant was in a poorly lit, high-crime area at night, manipulating his right side in a manner consistent with unholstering a gun. In contrast, Ms. Packer was in a parking lot across the street from a bar catering to college students and was walking away from the lot, conduct unrelated to the crime alleged in the anonymous tip. Cite to both Cruz and to your record. Under the totality of the circumstances, a court would likely find Ms. Packer's actions were consistent with that of a reasonable person being stopped and questioned by multiple police officers. I hope that helps and shows you the depth that you're supposed to go in your analysis. Wouldn't be application if I didn't at least mention counter-analysis. Your counter-analysis considers the alternative perspective. That doesn't mean the alternative perspective that the other side is going to rely on. It means the alternative perspective to the one that you took. There is very little in your memos that is so black and white that there isn't an alternative perspective. Here is where you consider that. Its purpose is to explain the best argument to the attorney that you are working for and the best argument against your position so that the attorney knows all sides. Your counter-analysis must do three things. It needs to explain the opposing argument. It needs to explain why a court is less likely to adopt that analysis. And it needs to return to your initial conclusion. So when you're doing counter-analysis, ask yourself the following. Does the counter-analysis rely on the kind of facts that have been persuasive to prior courts? Does it rely on mandatory authority or does it rely on an outlier? And is the outcome advocated in the counter-analysis consistent with the policy and the law behind it? Whether you are doing a counter-analysis or your analogic reasoning, you need to make sure that after you analogize the facts, you link that fact back to law. So you're not just saying, just like in Park here, but you're actually linking it back to the legal proposition that you were using that for. To help you practice doing this, there is more group work. The group work assignment is to read the group work application exercise, which is on Canvas. And then for your group to collectively write an application paragraph using the worksheet as a guide. And you must submit that application paragraph on Canvas no later than 11:59 Wednesday night. You should recognize these groups because you are going to be relying on the explanation paragraph you turn in. So based on that explanation paragraph, you are in the same group for this application exercise. Thanks very much. Hope this helps. I will see all of you soon.